So next up, we're going to talk about defenses. We started from the beginning. That's okay. What are the defenses that is used in criminal law? So there are a number of them, of course, and if you have a creative defense attorney, you can probably come up with more than we will learn about today, but that's okay. Let's talk about this. So, an alibi are just one of a number of established defenses for wrongdoing. Alibi is a proof that a suspect was somewhere other than at the scene of the crime, at the time of the crime. And that will demonstrate that the suspect was not guilty of the crime. And defenses generally rely on one of two arguments: the defendant is not responsible for the crime, or the defendant was justified in committing the crime. So, infancy is talks about young wrongdoers, and it's the status of the person who is below the legal age of majority. So, under early American law, infancy excused young wrongdoers of criminal behavior because presumably they could not understand the consequences of their actions. I will tell you, I still believe that, hence the juvenile justice class. And there are some things that need to be changed, maybe back to the way it used to be. So, insanity is a defense for criminal liability that asserts a lack of criminal responsibility due to some sort of mental instability. And when that happens, there is a process of having a competency hearing. And that competency hearing is a process that's held in different jurisdictions, and they determine insanity pleas. And so there are a number of insanity pleas and rules. I'm not going to go over these specific ones, but I would tell you to please take a little time and look at those ways that insanity is measured. So, intoxication, of course, is a defense for criminal liability where the defendant claims that the taking of intoxicants rendered him unable to form the requisite intent to commit the criminal act. So, there's two types of intoxication: voluntary and involuntary. And this could be definitely something that comes into play when we're talking about levels of intoxication. So, involuntary intoxication occurs when a person is physically forced to ingest or is injected with some sort of substance and then is unaware that the substance contains drug and alcohol. Now, voluntary intoxication is just simply probably what most of us do if we were to go out and have some cocktails. Is that we chose to drink. And the thing is, or use drugs, the thing that we have to remember is it is often used as an excuse, but it is not a defense that will be used or taken a look at. So ignorance of the law or a mistaken idea about what the law requires is also not a valid excuse. In some rare circumstances, people who claim that they honestly did not know that they were breaking the law may have some sort of defense if the following conditions are true. One, the law was not published, or it wasn't something that was recently known to the public. And also the person relied on an official statement from the law enforcement that was erroneous. So we have mystery of fact and mystery of law. I'm going to let you guys read a little bit more about that. So justification defenses, in certain instances, defendants will accept responsibility, but they're going to give some sort of justifying act. Four of the most important justification defenses are duress, self-defense, necessity, and entrapment. So as you guys move through these next slides, we will just go ahead and define them, and then you can go throughout your textbook and do a little more research on what these are. But we know that duress is an unlawful pressure, and this causes the person to act how they would not or otherwise act. Self-defense is legally recognized privilege to protect oneself or property from injury. We do have a duty to retreat that our duty to retreat is that we will avoid the conflict if that so is the case. Necessity. Defendant asserts that circumstances forced her or him to commit the act. And entrapment. Defendant claims that he or she was induced by a public official to commit the crime. So the due process clause in the criminal justice system is very important because when we're talking about due process, we're talking about provisions of the 5th and 14th Amendment to the Constitution. And they guarantee that no person shall be deprived of life, liberty, or property without due process of law. And to understand due process, it's important to consider its two types: procedural due process and substantive due process. So procedural due process is a provision in the Constitution, and it states that the law must be carried out in a fair and orderly manner. It requires that certain procedures are followed as we're administering and executing law so that an individual's basic freedoms are not violated. Now, substantive criminal law defines crimes and punishments, and it refers to the constitutional requirement that laws must be fair, they must be reasonable in a content, and must further a legitimate governmental objective. And the idea is that if a law is unfair or arbitrary, even if properly passed by a legislator, it must be declared unconstitutional. And that does it for this chapter 3 on criminal law. I would review some of those key terms and have a great day.